Good afternoon. Thank you, everyone. And thank you for joining us today. We welcome you to the second Investment Arbitration Talk Series, which is organized by King's College London and Triumvir Law in association with Asia Pacific Forum of International Arbitration. Before we begin, I would like to extend a special gratitude to Dr. Holger Hastemeyer from King's College London Forum on ITR for helping us organize this great event, and also Simon Weber from King's College London. That said, I take this opportunity to introduce the panelists that we have today. Thank you for joining us. We have amongst us today Ms. Kshama Loya from Nishit Desai Associates. We have Dr. Rishab Gupta, who's a partner at Shardul Amarchand Mangaldas. We have Michele Potestà, who's a counsel at Levy Kaufman Kohler. And last but not the least, we have Mr. Jagdish Menezes, who's an associate at Quinn Emanuel in London. The session will be moderated by our very own Trisha Mitra, who's an associate at Sherman Sterling Paris. I thank each one of them for sparing time and joining us today. I hope this session is as impactful as we envisage it to be. The essential idea behind organizing a session like this was to create an ongoing talk between young practitioners, academicians, and lecturers in the field of investment treaty arbitration. Without extending this introduction and boring you guys further, I would like to hand over the reins of this webinar to Trisha to take forward and of this webinar. Thank you so much, Trisha.
Thank you very much, Anubhav. I am very, very excited to be moderating this panel today on this topic. Enforcement, as many of you will know, deserves as much of a discussion and a thought as much as the arbitration itself. Very often when at the pre-arbitration stage of an investment treaty arbitration, there are two questions really that a client asks. First, are they going to win? And number two, if they win, how do they get their money back? So it is absolutely topical that we are having this panel today. And I'm very excited to have this particular panel discussing this topic. And that is because this panel is composed of not only practitioners, but also thought leaders in this field. All of them have extensive investment treaty arbitration experience. They've litigated extensively before courts, including in India and in the UK, and are also now part of the UNCITRAL Working Group 3 discussion on ISDS reforms. And I think, having spoke to these panelists, each of them will bring these varied experiences into their presentations. Each of them is planning to take a very different angle to this theme. I'm really excited for the audience to hear their thoughts on this. What I propose to do is to introduce each panelist's topic just before they speak. And having said that, I think it is now time to pass on the screen to Kshama, who will be giving us a brief introduction to enforcement. She will then tell us about the recent developments in enforcement related matters in India and provide a comparative view looking at other jurisdictions. Kshama, the screen.
At the outset, thank you, Trisha, Anubhav, and Simon for organizing this wonderful panel. This is special to me because this is co-organized by King's College London. I did my LLM at King's in 2010-11, and I owe a lot of my career growth to my professors, my FDI moot coaches, and to my education at King's. So thank you for having me on this panel. Enforcement, for purposes of enforcement, it is helpful to bifurcate investment treaty awards into those arising under the Convention on the Settlement of Investment Disputes between states and nationals of other states, known as the ICSID Convention of 1965. And awards not arising under the ICSID Convention. So first, let us look at the ICSID Convention. If both parties are member states of the ICSID Convention, the arbitration will be conducted as per the ICSID rules of procedure for arbitration proceedings. Member states are obliged to recognize an award rendered pursuant to this convention as binding and to enforce the award within its territories as if it were a final judgment of a court of the member state. Thus, the resultant ICSID award enjoys immunity from challenge in national courts of the member states by virtue of Article 54 of the ICSID Convention. Second, awards could arise out of arbitrations outside of the ICSID Convention, such as those administered in accordance with the UNCITRAL arbitration rules, ICC rules, or the SIAC investment rules. If the country of the seat and the country of enforcement are both members of the Convention on Recognition and Enforcement of Foreign Arbitral Awards, which is known as the New York Convention, the resultant awards could face resistance to enforcement in the country of enforcement on the limited exhaustive grounds set out in Article 5 of the New York Convention, and depending on whether the countries have availed of the territorial extension under Article 10 of the New York Convention. I would also additionally consider a hybrid category of awards resulting from arbitration in accordance with the ICSID additional facility rules. If only one of the parties is a member state of the ICSID convention, the investment treaty could provide for administration of arbitration under the ICSID additional facility rules. However, this does not offer the same immunity to the resultant award as an award under the ICSID rules of procedure for arbitration proceedings. So these awards are subject to the place of arbitration. However, the additional facility rules provide that an arbitration conducted under the rules may be conducted only in states that are parties to the convention, the New York Convention. So it can be inferred that this provision was inserted to ensure enforceability of awards made under the additional facility rules through the mechanism provided under the New York Convention. So that's the broad primer on enforcement of investment treaty awards. They are either ICSID awards or non-ICSID awards, and depending on the nature of these awards, the enforcement regime can be determined. Now, the enforcement of investment treaty awards in India. Not a single investment treaty award against India has been filed for enforcement in Indian courts. So why are we discussing this topic? Well, because presently India has more than 12 investment treaty arbitrations pending against it. It is also the most sought after country for foreign direct investment, so investor-state disputes would be a natural consequence. And because the closest judicial opinion we have on the issue of enforceability of investment treaty awards is unique and contrary to the view taken by courts of other jurisdictions, such as Singapore, UK, and USA. So I'll deal with this Indian judicial opinion later. Let me consider the international scenario first for context. Countries like Singapore, UK, and USA are member states of the ICSID Convention. They have special legislations that recognize ICSID awards. So for instance, Singapore has the Arbitration International Investment Disputes Act. Section 5 of the Act states that for purposes of execution, an ICSID award shall have the same effect as a judgment of the Singapore High Court. UK and USA also have similar legislations, although the USA, in the USA, one would need additional compliance with the Foreign Sovereign Immunities Act, so I'll not look into that right now. As for non-ICSID awards, courts in Singapore, UK, and USA have exercised jurisdiction on matters relating to challenge and enforcement of awards under their respective arbitration legislations. So in Singapore, the International Arbitration Act is applicable to arbitral awards made pursuant to international arbitrations seated in Singapore, as well as to those awards made in the territory of a New York Convention country. To date, Singapore courts have not been seized of an application for enforcement of a treaty award. However, in at least 2 cases of Sanam Investments Limited versus Government of the Lao People's Republic and Kingdom of Lesotho versus Swissboro Diamond Mines, the Singapore courts have entertained challenges to investment treaty awards seated in Singapore under the International Arbitration Act. In both cases, the courts exercised jurisdiction under the International Arbitration Act. So it can only be deduced that an application for enforcement of an investment treaty award would also be entertained under the International Arbitration Act in Singapore. In UK, courts have exercised jurisdiction over matters arising out of investment treaty arbitration under the English Arbitration Act in at least 4 cases, just to name them, involving Occidental Exploration and Production Company, or European Media Ventures, GPF versus Poland, and Tatneft versus Ukraine, which exactly dealt with enforcement of a treaty award. In USA, non-ICSID awards are enforceable in accordance with the Federal Arbitration Act. So in Chevron Corporation and Texaco Petroleum versus Republic of Ecuador, Chevron applied for enforcement in the US District Court. The District Court held that the award was enforceable under the New York Convention. So thus the position in the US is similar to that of Singapore and the UK, which brings enforcement of an UNCITRAL investment treaty award seated in a New York Convention state within the ambit of the Federal Arbitration Act. So, Trisha, we've looked at the international context. Now, what is different about India? India is not a member state of the ICSID Convention. Now, this deprives India of a regime that makes ICSID awards automatically enforceable in member states' jurisdictions. Thus, in an investment treaty arbitration against India, the resultant award would be a non-ICSID award. This means that if the award is against India and an enforcement application is sought in Indian courts, the proceedings will be subject to the laws of India. Now, the mechanism for enforcing foreign awards in India is set out in Part 2 of the Arbitration and Conciliation Act of 1996. Part 2 seeks to enforce New York Convention awards. Like in Singapore, UK, and the USA, one would believe that if any issue arises with respect to enforcement of an investment treaty award, and if the award is made in a New York Convention country with whom India has notified an arrangement of reciprocity under Article 10 of the New York Convention, it would be dealt with in accordance with Part 2 of the Indian Arbitration Act. However, in 2 cases involving investment treaty arbitration, unrelated with enforcement of investment treaty awards, the High Court of Delhi has opined that treaty awards are not governed by the Indian Arbitration Act. Now, this is a unique opinion, what we call as obiter dicta of the court. It's not still a ratio, so it does not have the value of a ratio decidendi. Now, I'll quickly look at the 2 cases. The first one is Union of India versus Vodafone PLC and another. In April 2017, Vodafone BLV invoked the India-Netherlands BIT to challenge a retrospective amendment of tax legislation by India that led to a tax demand of nearly 11,000 crores in Indian rupees against Vodafone, together with interest. While this arbitration was pending, Vodafone PLC, which is the parent company of Vodafone BLV, initiated parallel arbitration under the India-UK BIT, also challenging the same tax measure. India applied to the High Court of Delhi for an anti-arbitration injunction against Vodafone PLC. The court held that national courts in India were not divested of jurisdiction in an investment treaty arbitration. So the courts did say that they have jurisdiction in matters that arise out of investment treaty arbitration. However, the Delhi High Court went further and opined on the enforcement of BIT awards by Indian courts. The court held that although the subject BIT constituted an arbitration agreement between a private investor and the host state, it gave rise neither to an international commercial arbitration governed by the Indian Arbitration Act nor a domestic arbitration. So the court considered that investment arbitration disputes are fundamentally different from commercial disputes, as the cause of action is grounded on state guarantees and assurances, and so these are not commercial in nature. The roots of investment arbitration are in public international law, state obligations, and administrative law. So the court reiterated that when acceding to the New York Convention, India made the commercial reservation under Article 1, Subclause 3 to apply the convention only to differences arising out of legal relationships which are considered as commercial under the national law of the state making such a declaration. The second case was that of Union of India versus Khaitan Holdings Mauritius Limited. again, a Delhi High Court judgment where the court said that arbitral proceedings under a BIT are a separate species of arbitration. One that is outside the purview of the Indian Arbitration Act. The court, of course, relied upon the Vodafone case. But while assuming jurisdiction over the foreign investor and investment, the court said that the Arbitration Act did not apply in the present case. The case emanated from a bilateral investment treaty dispute and not from a simple commercial contract. So, as such, the jurisdiction of courts in relation to arbitral proceedings under a BIT would be governed by the Indian Code of Civil Procedure. So, these decisions are unique, and they could fuel uncertainty for enforcement of treaty awards in India. Although other Indian high courts are not bound to abide by decision of the Delhi High Court, these decisions would certainly hold some persuasive value. Until a contrary ruling is rendered, they are going to be a small part of the law of the land. And further, the Code of Civil Procedure would not apply in case of investment treaty awards, since the award is not a foreign decree or judgment which should be amenable to procedures under the Code of Civil Procedure in India. So this sort of forces foreign investors to look for enforcement avenues outside India under the present enforcement regime in India, unless the Supreme Court of India overturns this decision or does not use this rationale. The outlook for enforcement of investment treaty awards in India, if they follow the Delhi High Court decisions, would still remain a little uncertain. It's over to you, Trisha, unless you have any questions for me.
No, not at the moment, Kshama, but thank you so much for that, for sort of telling us the lay of the land. You have explained very nicely just how complex the question of enforcement might become in India, and how this question has been approached by the courts in Singapore, UK, and the US. One wonders whether the Delhi High Court, in its eagerness to not grant the anti-arbitration injunction, ended up throwing the baby out with the bathwater by saying that, by using this as the basis for its decision. But one can only wonder until there is more jurisprudence on this case. Thank you very much, Kshama, again. Next up is Jagdish, who will be offering us the practitioner's perspective to enforcement. Jagdish, you have the screen.
Hi, everyone. Thanks very much to the organizers. Just to check, are you able to see the
Yes, we can.
the slides?
Yeah.
Thank you. Right. So thanks to the organizers for inviting me to speak on this distinguished panel. My presentation is going to be about 5 questions relating to the enforcement of arbitral awards against states. I'm going to try to keep the focus on India, but as Kshama has so well caveated, it's not very hopeful there. The 5 questions are whether, where, what, how, and when. And I aim to offer you a practitioner's perspective. So turning straight up to the first question, and that is whether an enforcement strategy is needed. To give some context to this question, I'd like to share with you some statistics from UNCTAD for 2019. At least 674 investment treaty awards, known investment treaty awards, have been concluded by the end of 2019. And from those, about 21% of cases were settled, 37% were decided in favor of the state, and 29% were decided in favor of the investor, with monetary compensation awarded. And so I've said, lucky 21%, and it's unlucky for everyone else. because the 21% of cases that were settled, those are the ones that, have actually reached the final outcome. For the others who are successful, success is not really measured by a piece of paper that says that you've won. For an investor, success is when you make a recovery. And in that context, the question arises as to whether states actually pay and what is their track record of paying. But statistics show that recovery rates on damages awards are below 40%. So that makes enforcement critical to the overall strategy, because that's the only route to a true victory if the state won't pay or it won't settle. So my take on the question of whether an enforcement strategy is needed is it's always needed, and it's needed from day one, because the enforcement strategy is part and parcel of the exit strategy. Now, just on an exit strategy, one other point I'd add is that it's often you often talk about winning in terms of a monetary award, but the monetary award is actually only worth its name if it has money at the end of it. That takes me to the second question. Apologies. Right. Which is, where do I go? Every winning party has to locate jurisdictions in which the state has assets against which the award can be satisfied. And so the starting point of the answer to the question, where do I go, is, are there assets there? Assets, no, don't go, is the rule of thumb. Then the next point that you look at as a practitioner is whether your arbitration agreement and your award fit in. Do you actually fit in with that jurisdiction? And you'd always want to be checking with local counsel in that jurisdiction on documentation, on the process and formalities, and of course, quirks in the procedure. So when I say specific local requirements, to give you some examples, if you anticipate enforcing in Saudi Arabia, then an arbitration clause must be Sharia compliant. Otherwise, you can't enforce. Similarly, if you want to enforce in the People's Republic of China, you have to have selected an arbitral institution that PRC courts actually recognize. And you also have to properly identify that institution in your arbitration clause. A lot of you have heard about the ACMEA problem with intra-EU awards. So that is an award that is essentially issued in favor of an EU investor against an EU state. And that's another quirk that has developed in the EU legal system that makes EU jurisdictions very unattractive for enforcement. And lastly, limitation periods. Again, it's a practitioner's first look at point, because limitation periods for enforcing arbitral awards in many jurisdictions are often shorter than they are for enforcing foreign judgments. So it's something that can easily trip you up, and something you want to have a clear eye to. The next point on where do I go is then whether the jurisdiction where you fit in is actually arbitration friendly. Now that's a phrase you will hear a lot and you'll read a lot about. But I think it's better put as, does the country actually have a well-developed legal position on enforcing foreign awards? And you've heard from Kshama how difficult in India it is. India is clearly not within that category. If you have an ICSID award in hand, then of course, as she mentioned, domestic courts can't refuse enforcement of that award, unlike the New York Convention, where they can do so on very limited grounds. So if for instance, you find yourself in India, you trying to enforce an award against a state there, you might be stuck in a very lengthy proceeding debating the applicability of the Arbitration Act, as opposed to trying to get your client the money that it needs. And that is the test for whether or not a jurisdiction is arbitration friendly. Is it actually quick? Is it actually efficient? And are you going to get a result? I've also flagged there ancillary support. Now, it's very difficult most often to get freezing orders against states in many jurisdictions, but it is something, again, to watch out for. It can make a jurisdiction more attractive. Then comes the conundrum of good assets in bad locations. And on that topic, the first thing you think about is, well, should I just go to the home country of the state? Because of course, there's going to be a lot of assets there. But does it have an independent judiciary? Are you likely to get justice? And if you do make the recovery, if you are able to enforce, are you going to be allowed to freely, is the investor going to be allowed to freely transfer the funds outside the country? So those are the sort of considerations that can play into this conundrum. And I've already touched upon speed and costs. The last point that is relevant to the question, where do I go, is sovereign immunity. Now, I've deliberately put this consideration under the question of where, though most people worry about it when they think of what I'm going to discuss in my next question, which is what. And that's because this legal fiction, in my view, is one of the most significant obstacles in obtaining satisfaction of an investment award against the state. Most nations will afford some form of immunity to state assets, but the type of assets that actually fall for protection of sovereign immunity differ in different jurisdictions, which is why I say it's relevant to the question of where. So in some states where the case law is well developed, the general principle will be that assets that are used for sovereign means, so like military or diplomatic assets, cannot be attached, whereas assets that can be used for state commercial activities can be. And pausing there, it's worth remembering as a practitioner that no one tries to execute against, the ambassador's car or an F-16 plane that's just landed on the tarmac for refueling. Those are not the kind of assets that are ever going to be targets because they're obviously sovereign. The assets that actually come up for debate are most often mixed or they're questionable use. And that's why it is where you are that matters. It's what the domestic law regime uses to draw its lines on sovereign immunity that matters to your clients' prospects of success. Certain states might be more amenable to enforcing against assets which, as I say, are mixed use, maybe because there are high political tensions between the respondent state. So again, that's always something to watch out for and should play into your strategy. And lastly, some states have restrictions on enforcement requiring that the asset that you're targeting is somehow linked to the subject matter of the underlying dispute. That's a big red flag because that can make it very hard to enforce. Those are some of the considerations that go into where do you go. And that's a nice segue into my next question, which is, what do I enforce against? There are two practical elements to this question. The first is the features of the assets, and the second is the types of assets. And my take on it is that some types of assets have better features. So if I run through the list of what are the sort of features that the practitioner is looking at, is the existence of the asset publicly known, or is it something private that you found out about? Are those assets politically sensitive? That's often critical to the way in which enforcement actions play out. Where are those assets located in countries? So in countries like India, where you have different regional courts that might adjudicate on your enforcement action, what's the kind of attitude that a regional court within the country might have can be a relevant feature of the asset itself because of where it is. The ownership of the asset, is it held by a state entity? There's a lot of jurisprudence on when you can use the assets of a state entity to satisfy the award against the state. Is it an interest in a joint venture? Who is the other partner in the joint venture? Is it the host state itself where you're trying to enforce? How is that going to impact your prospects? Will you be able to accurately value it? And would it meet the full amount of the award when you collect? So those are the sort of features that come into play. And then on the assets themselves, I've listed some of the types of assets. Obviously, there are more. Financial assets are often considered low-hanging fruit because they're very easy to find. but that doesn't mean that it's necessarily easy to enforce against them. So an example is central bank assets or sovereign wealth fund assets. Many people look at them because they're often linked to commercial activities of states abroad, like making foreign investments or foreign exchange transactions. So that makes them a very popular target. But the challenge is to show that they're used for commercial purposes. And very often you'll find that they are mixed use assets. So there's a lot of scope for debate. So an example is that in 2018, a Moldovan investor went after the Swedish assets of the National Fund of Kazakhstan, which included shares in Swedish companies, bank accounts, and tax reimbursements. And the curious feature of the National Fund of Kazakhstan was that it was externally managed by the Bank of New York under a commercial agreement. And the Swedish court, rejecting Kazakhstan's plea for sovereign immunity, found that the assets were not reported in the central bank's accounting. And that showed that it was for commercial non-sovereign use. Intellectual property is another interesting type of asset. Very recently, the former shareholders of UCOS seized 2 vodka trademarks for 2 very well known Russian brands of vodka. And those were owned by a Russian state-owned company in the Netherlands. Real estate, well, there's hardly any better example than the infamous Sedlmayr case. Again, it's a case against Russia from 1998. It resulted in the first international arbitration award against Russia. And enforcement battles followed for many years until Sedlmayr tasted success after he found a Russian-owned apartment complex in Cologne in Germany. He was able to enforce against it, and from 2005, he began to receive regular rent payments from those apartments through a court-appointed receiver. So much so that by the end of 2008, Russia was forced to bid for her own buildings and ended up paying Sedlmayr. So that's a great example of an effective enforcement strategy. Lastly, movable crafts like planes and ships. These are often looked at as being sexy assets. And in theory, you could seize the asset and sell them. But a more likely outcome, in my practical experience, is that a state will often choose to pay out when you've managed to attach an asset like this, because these sort of assets are very high publicity assets, and they can have huge political implications. A recent example is Tanzania, where they were trying to resurrect their national airline, Air Tanzania. And an award creditor enforced against a brand new Bombardier plane just before it was going to leave Canada for Tanzania. And that caused a huge political storm in the country, and the country just settled the award. So my next question, and I realize I'm running out of time, so I'm going to move quite quickly, is how do I find the assets? The simple answer is, of course, by searching for them. And that's a time-consuming, a laborious and expensive process. Assets are hidden and assets can move. 3 practical pointers. Consider instructing a business intelligence firm. The sort of things you need to think about are they experienced in that jurisdiction? What's the strength of their source network? How discreet are they going to be? The second practical tip is to utilize local counsel. Where the assets may be located, that gives you eyes and ears on the ground. They can help you conduct registry searches. And the third practical tip is remember that discovery procedures can often direct an enforcement strategy. So for example, in the US, you get very broad discovery in aid of enforcement, in aid of enforcement proceedings, including against third-party banks. And there are newer techniques like seeking discovery over SWIFT data, which can help you locate assets or point you in the right direction. And of course, always avoid tipping off the state on potential targets. Otherwise, you'll find that those targets are not there. Last but not least, the last question, when do I make my move? And here I ask the question rhetorically, to move quick and thick or slow and steady. So there's no one single answer to this. And I've just tried to set out what are the sort of factors that you might think about when you're deciding when to make your move. You might go quickly because there's low-hanging fruit. You might go quickly because your client is fatigued by the litigation and spending of fees and it now wants a result. You might move in a thick way, by which I mean you might enforce in multiple jurisdictions in parallel, trying to use the element of surprise and increasing your chances before the state has a chance to react and put in place a defensive strategy. Or you might move slow because fast and aggressive enforcement tactics might annoy the government and eliminate your client's chance of getting a negotiated settlement. You might move steadily because it reduces the cost, it focuses the efforts. And sometimes, as I gave the example of Tanzania, one single attached asset or frozen asset is enough to turn the tide. So the key message from this is to develop a global strategy on the timing of enforcement proceedings and always to stay flexible. Some caution: time, logistics. Enforcement procedures are, as I said, time consuming. There's a lot of procedural formality. Annulment proceedings, you don't want to be caught napping with the state having launched annulment proceedings that result in a stay. And third, others like you, by which I mean other creditors who are trying to enforce at the same time as you. Last, must I move? And I always think that this is a very interesting question, so I wanted to end with it. My answer: not always. Like I said, your client might often be fatigued. Enforcement is expensive, and there are options to share the risk, such as by bringing in a funder, or some law firms will also work on a contingency or a recovery fee basis. You can sell the risk. In fact, there's a very vibrant market at the moment that is in the process of buying arbitral awards and then attempting to enforce them. Some vulture funds, in fact, look at arbitral awards as a category of distressed assets. So this can be a very neat corporate finance move. It brings liquidity, or it might mean the survival of your client itself, depending on its circumstances. Thirdly, create leverage, then you settle. So the enforcement strategy is just directed towards leverage creation rather than recovery. And then lastly, non-enforced enforcement, by which I mean using outside help. So this can mean getting the investors host state to impose unilateral trade sanctions, or voting against the extension of credit by international organizations like the World Bank or the IMF. And that helps induce the host state to comply with the investment treaty awards. And I'll end with the classic example from 2011, where in the face of multiple arbitral awards against Argentina, which Argentina was unwilling to comply with, the United States started voting against it in various international organizations like the World Bank and the Inter-American Development Bank. And other states in the Western world began to follow suit. And the US then suspended Argentina's preferential trade status. All of those political measures were actually what was effective in making Argentina begin to settle a number of the awards after. So that concludes my presentation. May enforce be with you. And I'll hand back to Trisha.
Thank you very much, Jagdish, for keeping it interesting, practical, and fun, just like you. These two insightful presentations will be followed by Rishab, who is today speaking about enforcement and sovereign debt restructuring. I can't wait to hear more, Rishab. Over to you.
Yeah, I guess you can't wait to hear more because you don't know what I'm going to say. Thanks, Trisha. Unlike Jagdish, I have no slides to put forward, nor do I have a very practical topic to talk about. This is quite academic, to be honest. It's a topic that I'd started thinking about before COVID had hit, and purely from the perspective of writing a law review article. But then COVID just became exceptionally busy for quite a few disputes lawyers like us. So I haven't really had a chance to think about it. The idea really today was to sort of share some preliminary thoughts with you. And if you have any feedback, you can share with me either through the chat section or afterwards. Just drop me an email. So just quickly, the starting point, of course, is, as both Kshama and Jagdish also said, that treaty arbitration and treaty awards could be very large in size and could be very expensive for states. I was just looking back at some of the statistics that ANO had come out with in 2017. And I have it on the side. It said sort of the average claim size as of 2017 was about 1.2 billion US dollars. The average award was about $486 million. And the average respondent cost, so the state's costs of litigating or defending a treaty case, was about $5 million. And of course, while these are sort of global figures, India is not a stranger to all of this. As Kshama also mentioned, India has been one of the most frequent respondent states, and there are quite a few very large treaty cases on foot against India at the moment. Now, if you just step back and think about an adverse treaty award, what exactly is it? It's an award which has been issued against the state. So it creates the obligation effectively on the central government to pay a certain amount of money. That amount of money is identified in the award itself. If the state doesn't pay, it accrues an interest. So just like any post-judgment interest or post-award interest that any decree or judgment from a local court would. And if the state doesn't voluntarily pay, you have the right to enforce it in the way that Jagdish described, whether by attaching assets within the country or outside. And you'll be hit with some defenses like sovereign immunity, etc. But that's sort of the process you follow through. So in a to a large extent, what an adverse treaty award is a form of sovereign debt. Even though it's not largely recognized as sovereign debt, no one would really talk about an adverse treaty award as sovereign debt, nor would any of your rating agencies, S&P, Fitch, etc., would consider it while deciding to rate sovereign debt. What they do take into account and what becomes usually the most parochial way in thinking about sovereign debt is sovereign bonds. So it's helpful to think about sovereign bonds then. What are they? Like corporate bonds, these are just ways to raise money for the governments. You have lots of different entities who would buy these bonds. You could have foreign governments, you could have foreign foreign institutions like the World Bank, IMF buying them, or you could have private players like private equity funds, hedge funds buying these bonds. The purpose of sort of bonds is effectively to raise money so that the governments could then invest those into the local economy for spurring jobs, for funding infrastructure projects, and so on and so forth. And typically, what these bonds would have is a maturity period during after which they have to be repaid along with whatever is the interest designated on them, and they would carry their own dispute resolution clauses, very often litigation in favor of New York or London. Now, if you think of COVID times, and which is why I think this topic perhaps is more topical today than it was when I started thinking about it, the amount of debt that any country would have, whether it's rich or poor, would balloon now. By some estimates, $15 trillion of money has basically been put into the local economies worldwide through budget spending and bond selling. And of course, some countries like the United States, the United Kingdom, etc., just because of how low their coupon rates tend to be, are in a much better position to service these bonds compared to the poorer countries. Now, the poorer countries are hit particularly badly because of the way sovereign debt works and because of COVID in particular, for a variety of reasons. First is, of course, that in the last 10 years, generally speaking, interest rates on these bonds have been slightly lower than what they used to be, which meant that a lot of poor countries, especially in Africa, have taken a much larger amount of debt than they would normally do. Now, because of COVID, the economy has totally gone down the tube. There is very limited economic activity. So the ability of these governments to repay debt goes down substantially. Plus, they have to, of course, raise more money to fund whatever additional health costs they have today and whatever additional infrastructure spending they need to do today. So what you have effectively is a position where in the near future, you would find that a lot of countries would effectively default on their debt obligations. And that, of course, then raises the question as to what can be done to try and effectively reduce the pain which a lot of these countries would face when that default, which I believe and many believe is inevitable, would happen. Now, there are sort of typically two things that people talk about. There are lots of policy ideas there, but sort of the most obvious two ideas to think about is one in terms of trying to apply some sort of debt moratorium. Now, a debt moratorium would be very similar to what, for example, in India we have today, where your private banks as well as your nationalized banks would give you a moratorium over interest repayment. And a lot of other countries, England, etc., have done the same. Now, the important part of debt moratorium is that, of course, your foreign governments and institutions might give you that debt moratorium, but in any such moratorium, you'll have to include the private investors. And this is where the overlap with treaty comes in, and I'll come to that a little later. But as bonds are ultimately bought also by private players, by hedge funds, private equity funds, and so on and so forth, you would necessarily want that in any debt moratorium that you agree upon, the same terms apply not just to your national governments and international institutions, but also to the private players. Because if you don't do that, then effectively what you have is that the public players are paying for the private players in any such debt moratorium. The same would apply. The second policy sort of move that one could consider is some sort of debt relief or debt restructuring. Now, sovereign debt restructuring is not something which is new. Typically, what would happen in such debt restructurings is that you would either have the face value of the bonds reduced, or you would have the existing, the defaulted bonds effectively replaced or swapped by new bonds, which would have lower interest rates and a longer maturity period. And of course, the bondholders would suffer substantial losses as a result, and these losses would typically be defined as haircuts. But again, the idea would be that you would not have, in any such sovereign debt restructuring, just the public players agreeing to that restructuring, whereas the private players continue to hold on to the other set of bonds and not participating in them, to the original bonds. Now, again, sort of just linking it to India, while I think it's unlikely that in the Indian context there'll be any default. But of course, all of this is very relevant to India as well, because as most of you would know, sort of India's sovereign debt rating has also been downgraded recently as a result of things which are happening because of COVID. And ultimately, beyond a point, there could be a possibility of such defaults should the economy continue to tank. Now, where does the overlap with treaty come in? And you must be wondering, why am I talking about sovereign debt restructuring when this is all about enforcement of treaty awards? I think generally speaking, there are two places where you would find an overlap. One is, of course, that, and it goes back to who ultimately is sort of the holder of these bonds. One area of overlap is that your private companies, your private investors are also holders of these bonds. And there've been cases out there, and most of you would know about the Aberclad decision, where you have effectively treaty tribunals saying that sovereign debt also qualifies as an investment under an investment treaty, just because the definition of an investment is so wide under at least the old generation BITs that your sovereign debt qualifies as effectively an investment. And then, of course, if there is a default on that and the state is not complying with it, all kinds of investment treaty protections would kick in, whether that's the umbrella clause, whether that's the FET clause, whether expropriation, and so on and so forth. Now, the purpose of this session is obviously not to talk about the viability of any such claim, but the purpose is more to say that what investment treaties do in such a scenario is that it makes it much harder to achieve any sovereign debt restructuring, which would involve the private bondholders. Because, as I said, one of the policy decisions would effectively be to try and restructure. And when you restructure, you would want everyone to participate in it. Now, generally, the reason why everyone would participate in it is because they would feel that they have exactly the same rights. And they would feel that unless they participate in the restructuring and unless they accept the haircut, there is simply no way for them to recover the entire amount. What the investment treaty route obviously does is it increases that moral hazard for those people who want to opt out of it, opt out of the restructuring, to think that, well, they have an alternative route whereby they could not participate in the restructuring and bring a treaty claim and try to recover the entire amount which they had invested. And that's precisely what happened with the 2005 sovereign debt restructuring in Argentina, that about 180,000 odd bondholders decided to opt out of it. They then decided to commence proceedings under the Italy-Argentina BIT, popularly known as the Aberclat case. And of course, that represented, I think, around $4.5 billion worth of money. Some of them decided to settle midway. So by 2010, I think you're left with only about 60,000 bondholders for about $2 billion of outstanding money. And in 2012, the decision came, which basically said that, yes, there is jurisdiction for even such mass claims. Ultimately, it all got settled. And my understanding is that the bondholders got paid about 150% of what they originally invested, which was at par with the other opt-outs who were litigating before New York courts. But that's one example where, of course, the treaty arbitration, and I'm not sort of commenting upon the rightness or the wrongness of this approach, but rather that the treaty arbitration, the treaty route makes it much harder to achieve sovereign debt restructuring. And my guess is, and my fear is, that going forward, because of the kind of times we are in today, and because of the likelihood of far more defaults going forward, claims like Aberclat would be more in the offing, and that may not necessarily be a good thing, especially from the perspective of poorer countries. The second place where the overlap happens is, of course, in the context of the treaty award itself. Now, as I said in the beginning, the treaty award is rarely considered by anyone as sovereign debt. I don't think any agency internationally puts it in the same category as sovereign debt in the form of sovereign bonds. But if you really think about it, there's no reason why it should be treated differently. And a sort of a very striking example of this is the Tetrin award that came against Pakistan in 2019. Now, what you had there was a $6 billion arbitration award in favor of Tetrin, an Australian investor who had invested in Pakistan. Just 2 months prior to the Tetrin award, IMF had agreed on a $6 billion bailout package for Pakistan. So what you had is, let's say in February 2019, IMF agrees on a $6 billion bailout package for Pakistan. And you have 2 months later, an arbitration award for approximately the same amount in favor of one single investor. Now, again, not commenting upon the rightness or the wrongness of any of this, but it is obviously problematic in circumstances where you have governments asking for bailout packages from foreign institutions, which are ultimately then funded by taxpayers all over the world, and then effectively creating an arbitration award, which is fully enforceable against the assets of these governments. And those companies who are holders of these awards not being subjected to any of the same rules that you would typically apply to holders of bonds, who have to necessarily then participate in sovereign debt restructuring. So these are just some problems and some thoughts as to what could be done. I mean, there are some ideas that have been put out there, some that I have been thinking about as well. Of course, the most obvious one is to think about the definition of investment in the treaty itself, whether or not sovereign debt should be included, should not be included, should be specifically excluded. Some treaties do that to a limited extent. So some of the US treaties, for example, especially the US-Uruguay treaty, for example, has a separate annexure which talks about how sovereign debt restructuring would be treated within the context of protections under a treaty. So that's one area that one could explore. The second thing one could explore is how you think about the non-precluded measures clause in a treaty. Now, of course, we all know that in the Argentinian context, the primary defense that was being raised is that the financial crisis raised essential security related issues, and that should act as effectively precluding all treaty protections. And that wasn't accepted by most of the tribunals, including the Aberclat tribunal. But perhaps that's something which could be made clearer, that financial crisis or crisis akin to financial crisis do give rise to essential security interest related problems. So those are two sort of language related things that one could think about. The third thing, of course, to think about is whether or not there is a way in which a mechanism could be created where adverse treaty awards are considered as part of a state's overall sovereign debt, and therefore any restructuring of that sovereign debt should necessarily take into account outstanding obligations under adverse treaty awards. Now, that's highly, highly controversial because that would effectively kill off this entire enforcement mechanism that, for example, Jagdish was talking about, because then what you have is effectively everyone, including your private investor who has a treaty award, being part of the same pain part of the same haircut that others are taking. But, of course, it's worth considering, I think, and there are arguments, I feel, in both directions as to why it may or may not work. The other option, of course, to explore, this probably is like the fourth solution, is to think about moving a little away from investor-state dispute resolution mechanism for something akin to claims arising out of sovereign debt defaults and moving towards a state-to-state dispute resolution mechanism. Now, again, investment treaties provide for that. We could have a multilateral system as well, but that could be another solution to think about. And finally, this is more short term, but I think it genuinely has some merit. Some people have talked about, and some agencies have talked about, having a moratorium on enforcement of treaty awards during the COVID crisis. I think that has a lot of merit. I mean, the last thing that a state should be worried about right now is trying to defend against enforcement actions for a treaty award, which rarely, if ever, rises up to the level of creating absolute irreparable injury for the investor if 2-3 months are lost in the enforcement process. Now, that doesn't solve the larger problem, but I think in the short term that might help. Okay, that's really it. Sorry, it was just mostly an academic thought than a practical thought, but I hope you found it interesting.
Absolutely, Rishab. I think that's a very original topic that you've brought up, and you've given us a lot to think about. Whether or not an award should be treated as a sovereign debt has many implications across how that would be implemented, what kind of laws would that impact, and then, like you mentioned, what would be the implications on enforcement. Thank you, Rishab, for a very, very interesting presentation, and I hope to see that paper someday. I look forward to reading that. Lastly, we have Michele, who will today be examining instances of misapplication or misinterpretation of the New York Convention by domestic courts and the crossover to investment law. The screen is all yours, Michele.
Thanks, Trisha, and thanks to the organizers. I'm very pleased to be on this webinar and to see so many participants online. It's really great. Let me try to share my screen. Voila. So as Trisha said, I will be taking a little bit of a different angle than the previous speakers because so far we have been discussing enforcement of investment awards. I will address the topic of investment arbitration as a potential enforcement mechanism, as it were, for commercial awards that have been refused enforcement. And so we could refer, as Trisha already mentioned, we could refer to this situation as one of crossover from commercial arbitration to investment arbitration, because investment arbitration here is being used as a tool to assist investors faced with domestic courts misconduct in connection with commercial arbitration. And so this intersection or crossover between the two regimes, investment arbitration and commercial arbitration, challenges what we could call the traditional architecture of international commercial arbitration. The traditional conception or architecture of international commercial arbitration is built on the finality of arbitral awards, with a division of competence between the courts at the seat of the arbitration, which are competent to review requests for annulment or setting aside of the award, and enforcement courts, potentially worldwide, which are competent to rule on the enforcement or non-enforcement of awards in that particular forum. And so this structure, this architecture rests in particular on the New York Convention and also on national arbitration legislation. Under the traditional conception, there is no recourse against the final decision of the court at the place of arbitration. Similar, there is no recourse against the final decision of the court at the place of enforcement. For instance, if an award has been refused enforcement in a certain jurisdiction, even if it should have been enforced under the New York Convention, because the domestic court has applied a wholly idiosyncratic ground that is not found in the New York Convention. Even in that case, under the traditional conception, this is the end of the matter. The party that wishes to enforce the award may try its luck in a different state, but there may not be assets, for instance, as we've heard from one of the previous presentations. So, but the question is this really the end of the matter if a party is faced with a final decision of a domestic court refusing, for instance, the enforcement of a commercial award under the New York Convention? And lawyers, we know, are inventive, and faced with these situations, parties dissatisfied with the way the domestic courts have behaved in respect of commercial arbitration have started to seek redress before a different forum, precisely investment arbitration or investment arbitral tribunal under an investment treaty. Incidentally, they've also tried similar relief before human rights courts, regional human rights courts, although I will not be discussing this. I will be focusing on investment arbitration. And so I have two illustrative examples. There's been obviously more, but I will use these two to illustrate this kind of crossover, the possibility to use investment arbitration as a forum to adjudicate domestic courts' alleged misconduct. And all of these decisions, I mean, as I said, there are others concern various scenarios. They can deal with the enforcement of arbitration agreements. They can deal with the annulment of awards. They can deal with the enforcement of commercial awards. The first case will be perhaps known to many of you, is the White Industries case that involved India as the Republic of India as a respondent. As you may remember, the case arose out of a dispute between an Australian mining company and Coal India, which is a state-owned entity. The dispute was resolved through an ICC arbitration seated in Paris, and the arbitration resulted in an award in favor of the claimant of White Industries, which then sought enforcement in India. Surprisingly, Coal India responded by filing an application to set aside the award before the Indian courts, although the seat was actually Paris. So this gave rise to a very complex set of litigation proceedings over which lasted almost over 9 years, both enforcement and setting aside proceedings, none of which actually resulted in a final determination. And so faced with this situation, White Industries initiated an investment arbitration invoking the applicable bilateral investment treaty. It claimed that its investment had been expropriated. It claimed a violation of FET. It claimed denial of justice. And also it claimed that its investment had not been provided, quote, effective means of asserting claims and enforcing rights. Importantly, this last standard, the effective means standard, was not included in the treaty, in the applicable treaty, in the basic treaty, as we say, which was the Australia-India treaty, but was found in a third treaty, the treaty with Kuwait. And so the claimants sought to incorporate via the MFN clause in the basic treaty this different standard that was to be found in a third-party treaty. And the investment tribunal, faced with this dispute, rejected the claims of expropriation, of FET, and denial of justice, but it allowed the claimant to import the effective means standard by way of the MFN, and found that the duration of the enforcement proceedings, which included more than 5 years on the docket of the Supreme Court, amounted to a breach of India's obligation to provide effective means of asserting claims and enforcing rights. So this was an interesting crossover from the commercial into the investment treaty realm. Incidentally, the White Industries award is a very important award in the history of India's BIT practice, a sort of watershed moment as many of you will know. In fact, it was the first unfavorable award for India in an investment matter, and it came almost as a shock to the Indian establishment. It made the government realize somehow that many BITs which India had signed had real teeth, that they could have real effect on the state and on the government. And so this case then prompted a thorough review of India's model BIT, which, as we know, in 2015, 2016, resulted in a completely revised model treaty, which takes a much more cautious approach to both substance and procedure. And importantly, and probably directly as a result of the white industries case, India no longer includes the MFN clause in its proposed BITs with third countries. Now back to the topic of this presentation. I have a second case also illustrates well this kind of interesting crossover, and it's the Frontier Petroleum versus Czech Republic case. In this case, the Czech domestic courts had refused enforcement of a commercial award on the ground of public policy under the New York Convention. Essentially, there was a bankruptcy issue in the underlying proceeding, and so the courts held that enforcement of the award would give the claimant priority over other creditors in the bankruptcy proceedings, and so essentially the commercial award was refused enforcement on public policy grounds under the New York Convention. And following the refusal of enforcement of the commercial awards, the claimant again sought to cross over to investment arbitration and commence a non-suitural arbitration under a BIT. And so again, the investment tribunal was asked to examine whether a national court, the refusal by a national court to enforce an arbitral award under the New York Convention for reasons of incompatibility with public policy, whether that refusal breached the bilateral investment treaty. And as you see on the slide, the tribunal was faced with the argument by the respondent that an ISDS tribunal lacks power to review a national court decision rendered under the New York Convention. It dismissed this argument and considered that its role, as you can see from the quote, was to determine whether the refusal of the Czech courts to recognize the award violated Article 3 of the BIT, which was the FET standard. And it went on to say that in order to answer this question, the tribunal must ask whether the Czech court's refusal amounts to an abuse of rights contrary to the international principle of good faith. And I'll come back to abuse of rights in a couple of minutes. The outcome of the case here was that the tribunal found no breach of on the part of the Czech Republic, and so the claims were dismissed. It found that that the Czech courts had not abused their rights to apply and interpret the New York Convention. These cases and others that I don't have time to discuss, but are somehow along similar lines, for instance, Saipem versus Bangladesh or GEA versus Ukraine and others, raise some interesting questions, both in terms of jurisdiction of an ISDS tribunal and merits. Starting from jurisdiction, the first question concerns the role, and we've already seen it through the slides, the role of investment tribunal in reviewing national courts' decisions applying the New York Convention. And in many of these cases, the respondents have argued that it was impermissible precisely for an investment tribunal to adjudicate this kind of dispute, because doing so would place it essentially as a court, would place it as a court of appeal in respect of a decision of domestic court. And obviously the New York Convention does not allow, in their view, to place a different tribunal as a court of appeal on a domestic court, which rather has the final word on these matters, as I was saying at the beginning. Now, these arguments have usually been rejected, and tribunals have reasons that the investment tribunal is in fact not arrogating the role of a court of appeal. It is not acting as an enforcement court in addition to or replacing the national court, and rather it's the role of an investment tribunal in this case is to assess whether a state's conduct amounts to a violation of the applicable BIT. And as a general matter, this seems right in the sense that there seems to be no good reason why an ISDS tribunal should not be able to entertain a claim simply because the circumstances at issue involve the application of another treaty, the New York Convention. There's many ISDS cases that may indirectly concern the application of other treaties, environmental treaties, etc. And here, just the fact, just because the New York Convention is at issue, does not seem to be in itself a bar to jurisdiction. Now, if the jurisdictional hurdle is passed, and there are other jurisdictional hurdles that normally come up in these cases that in the interest of time I cannot discuss, for instance, whether an arbitral award constitutes an investment under the ICSID Convention and the BIT. But if, assuming the jurisdictional hurdle is passed, on the merits, what is the test that an ISDS tribunal should apply to assess whether the national court's conduct amounts to a violation of the BIT? What is the standard under which the state can be held liable for conduct in connection with enforcement or non-enforcement of a commercial award under the New York Convention? And the standard that seems to be emerging from the case law is one precisely, and I've already hinted at that of an abuse of rights. So the principle of abuse of rights is generally understood as the exercise of a right for a purpose, for an end which is different from the purpose for which the right was created. The place of the doctrine or the principle of abuse of right in international law is not entirely clear, is not entirely uncontroversial, but it is arguably a general principle of law. And as a principle of law, as a general principle of law, it was relied upon by both the ICJ, the WTO appellate body, and investment treaty cases in a number of very diverse circumstances. So you see on the screen, again, the paragraph 525 of Frontier Petroleum that I already had in a previous slide, in which the tribunal precisely applied the abuse of rights standard in adjudicating this kind of claim. And just going one step further, the tribunal then noted that states enjoy a certain margin of appreciation in determining their own conception of international public policy. We recall that the issue at that case was whether precisely the Czech courts had abused their power, their rights to interpret the New York Convention, in particular the public policy ground for refusal of enforcement. And the investment tribunal said that a violation of the BIT would occur only if the decision of the courts was not reasonably tenable. And this is important to note. You see the last sentence in the slide. It says whether the decision was reasonably tenable and made in good faith. Because to say that the court's decision must be untenable is a very, very different standard from just saying that the decision by the national court was wrong. The threshold required to find a treaty breach in these circumstances is much higher than simply a finding of an error or a mistake in the underlying domestic court decision. And so other cases have adopted a similar approach. I've already referred to Saipan, which also, for instance, refers to the abuse of rights test. Now, in conclusion, what do these cases show us? Now, through the courts, states enjoy a level of discretion in the application and interpretation of the legal framework, which is most often the New York Convention. It can be also national arbitration law, but is not most usually the New York Convention in matters of enforcement. And of course, in those matters, mistakes by courts can happen, and this is entirely normal. But most mistakes made in the exercise of application and interpretation of the law, including the New York Convention, most mistakes will trigger no international responsibility. It is only when the national court's mistakes reaches the high threshold of, we could say, an egregious misconduct, an abuse of rights, or an untenable decision, it is only in those very limited cases that redress may be sought from an international dispute resolution body. And so in these narrow instance, I would say, ISDS assumes a sort of, we could say, supervisory role over national courts. I say supervisory because courts are those that, in the traditional conception to which I was alluding at the beginning, courts are those that exercise supervisory jurisdiction over commercial arbitration. So if courts exercise supervisory jurisdiction over commercial arbitration, in these limited circumstances, ISDS tribunals can exercise an additional layer of review, and this additional layer of review, supervisory jurisdiction, is restricted, however, to the examination of state conduct under a rather narrow window, which is the standard of abuse of rights. I think I've run out of time, but I'm happy to take any questions on this if there are any.
Thank you so much, Michele, for that very clear and sorry, I hear an echo. Okay, yeah. Thank you so much, Michele, for that very clear and very insightful presentation. I can see that there's a lot of audience questions coming in, but perhaps I'm gonna take them one by one and then mix them also with some of the questions that I had. Perhaps going back to you, Michele, and the standard of abuse of rights that you were discussing. There is another standard, another investment protection available to investors, which scrutinizes the actions of domestic courts, which is denial of justice. And I wonder whether, from your experience or from your readings, you have been able to understand what would be the interplay between the threshold for abuse of rights and the threshold for denial of justice.
Thanks, Trisha. That's a very good question. And in fact, most of these cases which have involved a court misconduct have also involved a discussion on denial of justice. Denial of justice is perhaps one of the oldest standards, we could say, investment standards in customary international law, and it is sometimes explicitly included in BITs, but there is no need to do so because it is understood it is part of the FET standard. However, it is a very high standard, and we know that a claim for denial of justice to be successful, for a claim to be successful, you can't again simply prove that there was a mistake on the part of the domestic court. You have to, some investment tribunal requires something much more systemic, a systemic failure of the entire domestic judicial system to ensure justice. And so that for instance, the White Industries award shows that the tribunal was unprepared. The investment tribunal was unprepared to find a denial of justice as a whole, let's say, by the Indian judiciary, and then sought refuge in this much more limited and unusual, we could say, the standard, which is the effective mean standard. Now, the effective mean standard is a less frequent standard, and it seems much more narrow. To come back to the abuse of right, abuse in this context, to me, as I understand it from the case law, it appears to be some sort of cross-cutting standard, because you will not find it anywhere codified in the BIT, but it results from the principle of good faith, and the Vienna Convention, for instance, says that treaty obligations must be performed of good faith, based on good faith. And so it is something as a general principle that comes in through that, and that you can apply in a cross-cutting way through the various standards that are involved under the BIT.
That makes absolute sense. Thanks, Michele. I have an audience question for Jagdish. Jagdish, the question is, what are your thoughts on targeting commercial awards in favor of states or state-owned entities as the assets against which to enforce BIT awards? So the example that is given here is that, For example, if a subsidiary of Germany is the award creditor in an ICC commercial arbitration, and in separate proceedings, a foreign investor has successfully sued Germany before an ICSID tribunal. If you were representing the foreign investor, would you consider enforcing your ICSID award against the German subsidiary's ICC award? Jagdish?
Thanks, Trisha, and thanks to whoever asked that very interesting question. I must confess, I've never ever given this any thought, because it almost seems counterintuitive a bit, because you're trying to enforce to get money against something that in and of itself has no money. So it's interesting because it raises issues of, well, are you subrogating yourself into the rights of the commercial award debtor, or are you simply just adding a layer to your enforcement problem? In my view, I wouldn't opt for such a route if I already had an ICSID award. Simple reason being, ICSID award, better enforceability than New York Convention award. If I had a New York Convention award, when I say I being the investment arbitration creditor, then I would ask myself, what am I going to gain by getting another New York Convention award? Is there some reason why that asset is going to be monetized any sooner than mine? And I suspect the answer will most likely be no.
Trisha, can I just jump in here? I mean, I agree with Jagdish that it's quite interesting and something which at least I don't personally also know of any instance. But ultimately, would it not be almost like a garnishee proceedings that you'll end up doing? Because presumably the fact scenario is that there is a third party which owes money to the German government, right? I mean, leave aside the subsidiary point. And you are owed money by Germany under your ICSID award. So in effect, what you're doing is you're going after third-party debt, right? And you are saying, I mean, that's no different to getting a garnishee order against the entity which owes money to the German subsidiary. So I wondered if the answer to this would not necessarily lie under German law at all, and would lie whether, so let's say the money is owed to the German subsidiary by, let's say, an English company. So you would go to the English courts effectively to get a garnishee order, isn't it? Or what in English procedural law they now call third-party debt orders.
Exactly.
Yeah, I've never, I'm just thinking off the cuff. I don't know, Jagdish, if you agree, disagree.
Well, it's interesting you mentioned that, Rishab, because as I understood the question, what was going to be enforced against the target was the commercial award. Now, that's why I said it's very interesting, and I don't think it'll happen, because what you would be interested in is going after the payor rather than the payee. So, for instance, let's say a country has a port or something, and shipping companies pay tariffs to dock at the port. What you're interested in as a target is the receivable that the state will receive. Whereas if you're taking a commercial award up as your asset, you're not getting a receivable, you're just getting another debt. So that's one of the reasons why I don't see in practice, as a matter of practical, unless there's some jurisdictional issue that you are trying to overcome by substituting your award with a different award. I don't see why you would do it.
Yeah. No, I think you're right. I mean, I was taking your sort of input. I was thinking of the award as effectively then a receivable from, in my hypothetical, the English company. And if one were to look at it as a receivable, then of course your typical garnishee proceedings should theoretically be available. But yeah, I don't know. I've never done it, so it's all just hypotheticals, I guess.
Great. I think it might also come down to who you're targeting, like Jagdish mentioned. Is it the award itself or the receivable? I think it'll be a question of understanding the nuance between who who would you be enforcing against? The payer or the payee, and that might determine the course of action in the commercial award sense. Okay, so we have another question which actually is for you, Rishab. Sorry, I just missed it. Yes. So the question is, doesn't the difference between public bonds and investment arbitration awards lay in their different reputational costs? So the question is, debt restructuring is generally considered an inherent risk in bonds. How can sovereign bondholders still argue loss of investment when there is a risk that they have already accepted?
So doesn't the difference, sorry, I'm just rereading the question. Doesn't the difference between public bonds and investment public? How can sovereign bondholders still argue loss of investment when that is a risk? So is that, I mean, the way I read the last part of the question, that seems to me to be suggesting that how can sovereign bondholders ever invoke BIT rights? And how can they argue loss of investment when they have accepted that there is a possibility of sovereign debt restructuring? Which, if I understand correctly, would largely then sort of go with my underlying thesis as well, that there is a problem here. And though I hadn't thought of it from that dimension, that therefore there is a problem in circumstances where tribunals decide to say that sovereign debt constitutes an investment under a BIT, and therefore the BIT rights are available. The problem with making, I guess the problem with making the argument that you've accepted that risk is the same argument that you always make in respect of political risk for any investment, right? Because you go into Bolivia and I'm just taking Bolivia as an example, but you go into Bolivia and you sort of try to build a power project. Of course, you take a political risk, right? Of course, you take the risk of expropriation or regulatory changes. But that by itself does not disqualify you from treaty protections. All that does is that political risk is a factor which should be taken into account when deciding the discount rate in determining damages. And therefore, your discount rate would be higher and your ultimate damages would be lower. I suspect that's how you would look at this question as well, that simply because there's a possibility that the state would default on its bonds, and therefore there is a possibility of sovereign debt restructuring, that by itself would not disqualify you from treaty protection. At best, it could give the state a reason to argue that you should not get your face value plus interest back. You should get something less than that because that's part of the risk you took, the political risk you took. So yeah, no, I'm not sure. While I like the sentiment because it sort of is consistent with my sentiment as well about this entire area of law, but I'm not really sure if it works. But it's still an interesting thought. Those are some immediate sort of views I have.
Thanks, Rishab. I also have a comment, and this goes to Kshama's presentation. The new Indian model BIT contains Article 27.5, and the wording, and I'll read it out for the benefit of the panel, is that a claim that is submitted to arbitration under this article shall be considered to arise out of a commercial relationship or transaction for purposes of Article 1 of the New York Convention. So the comment is that maybe if this provision of the model BIT were to be adopted into BITs, might help with enforcement of awards in India. I don't know if anybody has a comment on that.
Yeah, Trisha, I agree with you. That's maybe something that India may have considered, but the Delhi High Court did not obviously consider, because anyway the model BIT is just a model BIT, right? But yes, that can certainly help to remove this obstacle that we are now facing with respect to enforcement of treaty awards, only because we have chosen the commercial Article 1, Subclause 3 of the New York Convention, just to restrict to commercial disputes.
Right. Staying with you, Kshama, there is actually a question for you, and that is regarding sovereign immunity, and whether, how do you think that courts in India would, what would be the scope of sovereign immunity that it would apply as and when it is faced with a question of enforcement of an investment treaty award?
I don't really see sovereign immunity as a problem in India as much as it would probably be in countries like maybe Russia. But yes, we are yet to see a situation where this could very creatively be argued by Union of India if it is faced with an enforcement issue.
I mean, if I could just jump in there, Kshama, correct me if you disagree, but see, ultimately, the India doesn't obviously have a State Immunities Act, right? Like the UK has, or the Foreign Sovereign Immunities Act in the US. So all you have really is a couple of provisions in the Constitution, and you have, one provision in the CPC. And the big debate that you sort of have outside of India between absolute immunity and qualified immunity, that is not there under any statute in India, but you do have those Kenyan Airways and all those other airline decisions coming out of high courts in India, which do talk about the same qualified versus absolute immunity concept. So if and when you have those, arbitration awards being enforced, and, I'm drawing a distinction here between arbitration awards being enforced against the government of India versus arbitration awards being enforced against foreign governments, right? Because when it comes to enforcement against India, the relevant provision is in the Constitution. And then when it comes to sort of foreign governments, it's in the CPC. But keeping it with the foreign governments, the UCOS kind of issue, there, I don't think the position is that different, to be honest. I think it would be the same analysis that you would apply in any jurisdiction, except that it won't be as sophisticated, because there isn't that much either statutory law or law by way of judicial precedent. But it's the same, that, as long as you're using the assets for commercial purposes, broadly speaking, that asset is available for execution. And if you're using it for sovereign purposes, it's not. So it's the same sort of qualified immunity concept which would apply. But that's not the same, I think, if you're trying to enforce it against Indian government's assets. There you will be hit by a different analysis altogether.
Absolutely agree with you, Rishab. That's where, probably will not be hit by the sovereign immunity provision. But yes, like you rightly pointed out, the jurisprudence is not very sophisticated, or not very developed in India. When you yet to see how this can be very creatively used by India in case any case comes up for enforcement here.
Right. I have a last question, and I want to take this opportunity firstly to thank the audience for being so engaged. We're receiving so many interesting questions. But I'm looking at the time, and I realize that that we unfortunately won't have time for our questions. But I'm going to take one last question, and that is, again, keeping to enforcement in India, and that is the decision in the Kolkata Port Trust case by the Calcutta High Court, where I understand that the Calcutta High Court proceeded on the assumption that the Act applies to investment treaty awards. And I wondered whether Rishab or Kshama would have any comments on the approach of the court in that case, and in contrast to what Delhi High Courts have.
I don't know the answer because I haven't read the decision. Is this Lou Dreyfus? Right. Okay. No, I haven't. I haven't read the decision, so I wouldn't know the answer. No. Sorry.
So, Trisha, this is an old decision of the Calcutta High Court, right? And while I don't exactly remember But I think, again, this was an anti-arbitration injunction. And yes, the Calcutta High Court did, if I recall correctly, and please correct me if I'm wrong, did not quite elaborate on that point, but just mentioned in very few statements that the Arbitration and Conciliation Act would apply. What we see differently in the Delhi High Court decisions is sort of a very elaborate analysis of how investment treaty cases are different. It has a lot of elaboration or elucidation on, again, the New York Convention, the effects of investment treaty awards on the public exchequer, and how they are really different from international commercial arbitration. So while, yes, the Calcutta High Court did mention that the Arbitration and Conciliation Act would apply, so to say, but the Delhi High Court did go ahead and quite lucidly elaborated on why the Arbitration and Conciliation Act would not be applicable. That's the only difference I see.
Right. Fantastic.
If I could just throw in
Yes.
my 2 pence on just one thing. I mean, there's obviously a lot of concern about how Indian courts are dealing with enforcement of arbitral awards, particularly against India. But one thing that I think we should never lose sight of is, will an investor actually try to enforce an arbitral award against India in India? Obviously, all the uncertainty, costs, time, political influence, etc., that comes up. Or is it better for the investor to start looking abroad? One, because India has a lot of assets abroad. India is actually, very properly into the dollarized economy. So there's plenty of stuff you can find if you go hunting. And two, in a broader context, or sort of in a more optimistic context, India is a place to do business, right? I mean, it's the second largest population in the world, still growing. Do you really, is enforcement and recovery the be all and end all of an investor's goals, or do they want to stay in India and cultivate a relationship with India? So is a negotiated settlement a better approach? So I think that's just a thought I wanted to throw out on the topic.
I think that's a very good comment.
Well, I'm not going to add anything to the brilliant presentations and comments that have already been made. I think this has been an absolutely fascinating discussion, and I wish we had hours. I felt like this conversation could have gone on for longer. But let me take this opportunity to thank Rishab, Michele, Kshama, Jagdish, all of you. We also have with us Simon Weber from the King's College Forum for International Dispute Resolution. He will be giving the final vote of thanks.
Thank you, everyone, indeed, on behalf of the King's Forum on IDR for a very, very interesting session. We have created a good momentum with this webinar series, I think. I've seen over 120 participants in this webinar, which tells us that we could think of a third webinar. Let's see. Of course, thank you very much to Kshama, Jagdish, Rishab, and Michele for joining us today, also to Trisha for moderating the panel, as well to everyone who's been here for your interesting questions. This was a very, very good session. I really enjoyed it. Thank you also to Triumvir Law for the support, in particular with all the technical stuff that you've taken care of. And to the Asia Pacific Forum for International Arbitration. We will obviously keep you all informed about our next, the next thoughts that we have and the next webinars. There's just one last thing that I would like to say. So you will soon receive an email from Triumvir Law with a feedback form. We would all very much appreciate everyone to fill out this form so that we know what we can improve, what was good, and what should remain the same. In that case, on behalf of King's College London, thank you very much. Have a lovely weekend and stay safe, everyone.
Thank you very much. Bye-bye.
Thank you.
Thank you.
Bye.
Bye.
Thank you.
Thank you. Thank you for joining us today. Thank you.